Recent events have put Aboriginal deaths in custody back in the public spotlight, but examination of the data reveals a narrative that is just as destructive for Aboriginal people as the New South Wales Aborigines Protection Act of 1909. We will examine in detail the facts, the numbers and the propaganda to understand what is behind the phenomenon of Aboriginal deaths in custody and uncover who the victims are of those Aboriginal people that are incarcerated for their crimes. Further, we will discover if police or corrective service officers have been convicted of murder for deaths in custody and examine if the coroner's reports on the deaths match the narratives, or are these actually media myths designed to create mayhem by dividing Australians by race. My fellow Australians, I'm John Andrews and welcome to a new episode of Advancing Australia, Aboriginal Deaths in Custody, Murder, Myth or Mayhem. This is the first in a series of video essays. On race relations. Race relations and identity politics are the main weapons that are used to divide Australians from each other. Every time a centre-right or right-leaning government take a step towards the left to accommodate a radical position, the left take another giant leap left and the right dutifully follow. This situation needs to be addressed and a nationalist perspective can help navigate back to a sensible position. There are two issues that must be very briefly addressed. There is a trend on the left to cancel or attempt to silence non-Aboriginal voices when discussing Aboriginal issues. But Australian citizens have a franchise to exercise at the ballot box, and all our voices contribute to the body politic. That franchise is non-negotiable. Silence no longer an option. Additionally, there needs to be a distinction in language on nomenclature. The word Aboriginal comes from the Latin ab origine, meaning from the beginning, and the word Indigenous comes from the Latin indigena, meaning native. Like many of you, I was born in this country. As such, this is our native home. We may travel the world, but we will always call Australia home. This feeling, this love is at the heart of every Australian nationalist. The left place a high degree of importance on language, with good reason, and I do too. I am a native-born Australian. I am Indigenous to this land. However, from the perspective of English settlers, the Aborigines were here from their beginning. For this reason, I shall use the term Aboriginal now and always. First thing we're going to look at is an article from the ABC. And the article states here in relation to this protest, 6 protesters arrested at Sydney Black Lives Matter march. The article states, Mr. Gibson told the ABC the protest was being held to demand justice for David Dungay Jr. and other black people who have died in custody, and following an inquest, New South Wales Commissioner Peter Severin acknowledged systemic issues and clear failings contributed to Mr. Dungay's death. So I searched the coroner's report into Mr. Dungay's death for both the term systemic issues and what was the other one? Clear failings. And I found one result only, and that was for systemic issues, and it was in relation to Section 2, why was an inquest held? That's a quote. The quote goes on, 2.7, inquests have a forward-thinking preventative focus. At the end of many inquests, coroners often exercise a power provided for in Section 82 of the Act to make recommendations. These recommendations are made usually to government and non-government organisations in order to seek to address systemic issues that are highlighted and examined during the course of an inquest. Recommendations in relation to any matter connected with a person's death may be made if a coroner considers them to be necessary or desirable. End quote. This is the nature of the reporting on the issue, emotional language and conflation with narrative construction and maintenance. As you will see, this is a theme of the reporting and the language, the discourse around the issues. It is a meta discussion where facts are irrelevant in the maintenance of division. In the prologue to Richard Broom's Aboriginal Australians, A History Since 1788, 4th edition, the author opens his book with an account of the life and death of Malcolm Smith. And I know that's the 5th edition on your screen, but I read the 4th edition. It says, quote, in Denton, New South Wales in 1965, 11-year-old Malcolm Smith and his brother Robert borrowed push bikes leaning against a bus shelter and went joyriding. This small act led to the involvement of the police, welfare officers and the court. Malcolm's widowed father, who was in seasonal work and thus not always present, was judged an unfit parent. The boys were taken and placed in a series of homes and foster care placements, where their Aboriginality was undermined, even denigrated. As a confused youth, Malcolm found himself behind bars where his Aboriginal identity was somewhat affirmed by other Koori men. The jail door revolved and he was finally reconnected with family as best any foster youth could. In 1980, in the hope of pleasing and defending his sister, he outraged her by killing her boyfriend who had been bashing her. He was sentenced to 4 years for manslaughter. In Long Bay Jail, he expressed interest in the Bible and was given a tape of the book of Matthew. He began to paint religious images, but became delusional, said he was Jesus Christ, then claimed he was evil. Mental torment mounted, reflecting his alienation from family and his Aboriginal cultural roots. Self-hatred engulfed him, and driven by the passage of Matthew, quote, "And if in thine own eye offend thee, pluck it out," Matthew 18:9. He drove the handle of an artist's brush into his eye and brain while in a toilet cubicle, collapsed and died. He became one of 99 cases investigated in 1990 by the Royal Commission into Aboriginal Deaths in Custody. So when I look at the report into the inquiry of the death of Malcolm Smith, Royal Commission into Aboriginal Deaths in Custody reports, and that's everything that I'm going to quote from you is linked in the description of this. Malcolm Charles Smith, Genocide and the Aftermath of Assimilation. This is a quote from the report. No one at the Malabar Assessment Unit, it's at Long Bay Jail, that day was at fault. Each officer was doing his or her duty in the normal way and had no reason to expect what would happen. When Malcolm inflicted the fatal injury on himself, the officers responded promptly and sensibly and can only be commended for the way they handled a most distressing incident. Equally, the medical attention which he subsequently received was beyond criticism. However, this is a 31,000-word report. It's very extensive. Malcolm died in 1983 and the report was finalised in 1989. And it goes on to say, again, quote, "To attempt to solve the Aboriginal problem by the deliberate destruction of families and communities, which was the policy of the Aborigines Protection Board and to some extent its successor, the Aboriginal Welfare Board, not only wrecked individuals' lives, but is seen by many Aborigines as falling squarely within the modern definition of genocide." And there's the report there. Now, Peter Reid is cited as a source in the report, and he is the first academic, I believe, that coined the term stolen generations. Now, to date, I've found no evidence that this was the intent of the policy. There's no evidence presented in the report to support that conclusion, and also there's much argument in academia about what we colloquially refer to as the stolen generations, and that is a topic I'm very interested in, but it's not the subject of this video. There is a list of exhibits at the end of the report, but they are not attached to it. They're not available online. Further, when reviewing the New South Wales Aborigines Protection Act 1909, and that's New South Wales said that, it is possible to discern intent from it is not possible to discern intent from the legislation. At some time in the future, I will have to physically track down the exhibits and read Hansard, the recordings and proceedings of Parliament, if available, to see what the creators of these documents were saying. At the moment, I have no evidence before me of their intentions. However, I have to be clear, parts of the legislation are very confronting. Aborigines Protection Act 1909. Let's see, no, I don't have that up at the moment. But again, all the links are here. And so, point 6, the board may appoint local committees to act in conjunction with the board and also officers to be called guardians of Aborigines. Such committees and guardians shall exercise and perform the powers and duties prescribed by this Act and the regulations. 7, it shall be the duty of the board to, and I'm quoting sort of selectively here, but to distribute blankets, clothing and relief to Aborigines at the discretion of the board, to provide for the custody, maintenance and education of children of Aborigines, to maintain and regulate the use of reserves, to exercise a general supervision and care over all matters affecting the interests and welfare of Aborigines, and to protect them against injustice, imposition and fraud. 8, All reserves shall be vested in the board, and it shall not be lawful for any person other than an Aborigine or an officer under the board or a person acting under the board's direction or under the authority of the regulations to enter or remain upon or be within the limits of a reserve upon which the Aborigines are residing for any purpose whatsoever. 10. Whosoever not being an Aborigine or a child of an Aborigine lodges or wanders in company with an Aborigine and does not, on being required by a justice, give to his satisfaction a good account that he has a lawful fixed place of residence in New South Wales and lawfully means to support and means of support, and that he so lodged or wandered for some temporary and lawful occasion only and did not continue to do so beyond such occasion, shall be guilty of an offence against this Act. 16. 1. If it appears to a court on complaint by or on behalf of the board that any relative is of ability to maintain or to contribute to the maintenance at the cost of the government of any child of an Aborigine under 16 and over 5 years of age, the court may upon summons order such near relative to pay the board a reasonable sum of instalment or otherwise as the court directs for or towards the past and future maintenance of such child, whether such child be alive at the time of the application, and the future maintenance of such a child. End quote. Okay, and that was repealed in 1969, following the 1967 referendum, and it was replaced with the Aborigines Act 1969, which proceeded on to 1983, and then it was then that piece of legislation was repealed by the 1983 Aboriginal Land Rights Act. So we can note here that this is incredibly draconian legislation that controls every aspect of the lives of Aboriginal people. Okay. The mental health of prisoners. Australian Institute Health and Welfare, the Health of Australian Prisoners 2018, released in May 2019. This report says 2 in 5 prison entrants had been told they had a mental health condition, with almost 1 in 4 currently taking mental health related medication. About 2 in 5 prison entrants and prison dischargees reported a previous diagnosis of a mental health condition, including alcohol and other drug disorders. Women were more likely than men to report a history of mental health condition, 65% of women compared to 36% of men, and taking medication for a mental health condition, 40% of women compared to 21% of men. Non-Indigenous prison entrants were more likely than Indigenous entrants to report currently taking medication for a mental health condition. 3 in 4 deaths in prison custody were due to natural causes. Between 2013 and 2014 and 2014-2015, 115 people died in prison. Almost 3 in 4 of these deaths were from natural causes, and 1 in 4 were due to suicide or self-inflicted injuries. 1 in 5 prison entrants reported a history of self-harm. More than 1 in 5, 21%, prisoners reported a history of self-harm. Women entering prisons, 31%, were 1.5 times more likely than as men to report a history of self-harm. More than 1 in 4 young prison entrants reported a history of self-harm, higher than any other age group. So it's pretty devastating sort of numbers. The prison population. We're looking at the Australian Law Reform Commission here. Practice into justice inquiry into the incarceration rate of Aboriginal and Torres Strait Islander people, report 113. Section 3.13, Aboriginal and Torres Strait Islander people are disproportionately represented in Australian prison populations. In 2016, Aboriginal and Torres Strait Islander people constituted just 2% of the Australian population, but comprise more than 1/4 of the national prison population. 3.14, as shown in figure 3.1 below, the extent of the overrepresentation varied by state and territory. For example, in Northern Territory, Aborigines and Torres Strait Islander people constituted 30% of the general population, but 84% of the prison population. In Victoria, Aboriginal and Torres Strait Islander people constituted 1% of the general population and 8% of the prison population. and 3.7. Nationally, the proportion of prisoners with a prior record of imprisonment was very high. 3/4 of Aboriginal and Torres Strait Islander prisoners and half of non-Indigenous prisoners 2016 had been in custody on at least one previous occasion. And we've got here the Australian Bureau of Statistics prisoner character snapshot. As at 30th of June 2018, there were 42,974 prisoners in Australia. 7 out of 10 prisoners were sentenced, while 32% were unsentenced. Aboriginal and Torres Strait Islanders accounted for over 1/4, 28%, of the total Australian prison population. And yet the total Australian population, 18 years and over, was 2% of the population. So you can see a massive overrepresentation here. Now we've got to look at the causes of that, and that is victims of crime. And you can see here, latest release. This is the absolute latest data we have available on victims of crime. It was released in July last year. And if we go down homicide, I've got all sorts of numbers here, but I'll just go through them very briefly. Assault. The number of... so there's a note first. This is particularly Aboriginal and Torres Strait Islander victims of crime. Note from the ABS. Statistics on Aboriginal and Torres Strait Islander victims of crime are presented for New South Wales, Queensland, South Australia and the Northern Territory. Based on the ABS assessment, Indigenous status data for other states and territories are not sufficient quality and or do not meet ABS standards for national reporting. Okay, so there is data available, but it's not of a standard the ABS are happy to share. So as such, I'm just going to focus on this document. Assault. The number of Aboriginal victims, Aboriginal and Torres Strait Islander victims of assault recorded in 2019 were, in the Northern Territory, 69.7% of victims were Aboriginal and Torres Strait Islander, and they're 30.3% of the population. In New South Wales, 6.6% of all victims of assault, 3.4% of the population. And in South Australia, 14.4% of all victims, but 2.5% of the population. Of the Northern Territory Aboriginal and Torres Strait Islander assault victims, the majority were female, so 3/4. More than 1/4 were aged between 25 and 34. Half occurred in a community location in the Northern Territory, which is to say not a private residence, so these assaults are happening in public. Around 2/3 of assault occurred in a residential location in New South Wales and South Australia. Sexual assault. The numbers of Aboriginal and Torres Strait Islander victims of sexual assault recorded in 2019 were 8.4% of all victims in New South Wales, but 3.4% of the population. In the Northern Territory, they comprise 36.7% of the victims of sexual assault, but 30.3% of the population. In Queensland, they were 11.6% of victims, but 4.6% of the population. And in South Australia, 6.1% of victims, but 2.5% of the population. The victimisation rate for sexual assault increased between 18 and 19. And for Aboriginal and Torres Strait Islander victims of sexual assault, the majority were female, between 80 and 95%, depending on the state. About 1/3 were aged between 10 and 14 years of age in New South Wales. So that's overall. So in New South Wales, 37% of sexual assault victims were aged between 10 and 14, children. Queensland, 32%, child victims of sexual assault. Northern Territory, 28%, children. Okay, sexual assault victims in Australia, Aboriginals, aged between 10 and 14 years old. In South Australia, about 1/4, 24%, were aged between 15 and 19. Okay. Most knew their offender, between 62 and 84% across the territories. And the most common location was residential. Okay, 49% in the Northern Territory and 75% in New South Wales. So, I mean, in the Northern Territory, half of the sexual assaults are occurring outside of a residential setting. There's no specific national data available on either perpetrator or victims of crime such as robbery, unlawful entry with intent, motor vehicle theft or other theft. Okay, so all we have here is serious, very serious crimes. Domestic violence. Now I'm not sure if I've got that data available. No, I don't. But I've got the link in the description. 12% of women killed by an intimate partner identified as Aboriginal in New South Wales. 12%, but they comprise 1.7% of the population. 31% of men killed by an intimate partner identified as Aboriginal, and they comprise 1.6% of the New South Wales population. So the official numbers are there. Trend Australia-wide of Aboriginal people committing crimes against other Aboriginal people, and the activists are totally silent on the issue. Their media allies totally ignoring the problem. Let us compare the numbers we have seen with how they are reported. The Guardian. Indigenous prison population continues to increase while non-Indigenous incarceration rate falls. The article reports imprisonment rate. Indigenous rate 1,935 people per 100,000 adults when adjusted for average age among Indigenous Australians, and 166 per 100,000 for non-Indigenous adults. Okay, so 1,935 versus 166. And you'll note that the figures for Aboriginal Australians were adjusted up for average age, but the rate for non-Aboriginal people was not. Most prisoners in the Northern Territory were Indigenous, 30% of the population, but committing assaults at twice those rates. And the word, in that article, the word crime, conviction or victim does not appear anywhere in it. Absolutely disgraceful. Deaths in custody. I don't have this up because this is a spreadsheet. This is from the Australian Institute of Criminology. They keep statistics via the National Deaths in Custody program. And I've got a link again. Table B1 of their 2018-19 Deaths in Custody spreadsheet revealed that 18% of all deaths from all causes were Aboriginal. From a prison population, that was 28% Aboriginal. Aboriginal people are underrepresented in deaths of all causes within the prison system by a third, or within the custody system, I should say. That is that the death rates are a third lower than the rest of the prison population. Okay, not reported. Indigenous life expectancy and deaths. So this was released July last year, 2020. In 2019, the death rates for Aboriginal people of all ages was 440 per 100,000, and non-Aboriginal people was 652 per 100,000. Okay, so non-Aboriginal people have a higher rate of death than Aboriginal people. The Australian Institute of Criminology Statistic Report 31, Deaths in Custody Australia 2018-2019. The rate of Indigenous prisoners was 130. Death rate for Indigenous prisoners, the death rate was 130 per 100,000. And the death rate in the community is 3.11 per 100,000 for Aboriginal and Torres Strait Islander population aged 18 and over. Okay, so Aboriginal deaths in custody 18-19, there were 13. 11 were from natural causes. One was a self-inflicted hanging, and one was via external trauma. Natural causes. Quote, of the 11 Indigenous deaths resulting from natural causes, the specific cause of death recorded in 9 cases. 2 of these deaths were from heart disease or related ailments. 2 were from cancer, 2 were from respiratory conditions, 2 were from other diseases, and 1 was stroke. Natural causes was the most common cause of death for Indigenous and non-Indigenous prisoners. The death rate for natural caused deaths was similar for Indigenous prisoners and non-Indigenous prisoners. Self-inflicted hanging. Hanging death rates among Indigenous and non-Indigenous prisoners were also comparable, 0.02 versus 0.03 per 100. The rate of Indigenous hanging deaths has been lower or the same as the rate of non-Indigenous hanging deaths in all but 2 years, 2001 and 2002. External trauma. External trauma includes head injuries and gunshot wounds. External trauma can also include unlawful homicide and justifiable homicide. Now I'm going to move on to case studies. Okay, now this information comes from The Guardian. Deaths Inside, Indigenous Australian Deaths in Custody 2020. Quote, more than 400 Aboriginal and Torres Strait Islander people have died in custody since the end of the Royal Commission into Aboriginal Deaths in Custody in 1991. The Royal Commission emphasised the importance of monitoring and maintaining accurate data about deaths in custody. Despite public reporting and tracking through the Australian Institute of Criminology's national program, detailed up-to-date information is hard to find. That's actually not true. In 2018, Guardian Australia's reporting team collected and analysed all available coronial data and other sources to build this searchable database. 1 year on, we have updated Deaths Inside, which tracks every known Indigenous death in custody in every jurisdiction from 2008 to 2020. You can download the data. We have added new search functions. We want to thank all the families that participated in the database containing descriptions of self-harm. We understand this, okay. So now I chose, totally at random, and I mean totally at random, 14 cases, 13 from New South Wales. I chose those deliberately because I'm in New South Wales and I'm familiar with how to search the databases, the online resources. I also chose one in WA, and that's because it's referenced a little bit later on. Okay, so we're going to go through these now. What have I got here? No, we'll get to that. So I won't find each individual one. 2019. Is that? Okay. Here we go. Unknown. The Guardian reported it thus. The 20-year-old Aboriginal man fell 10 metres to his death while being escorted from Gosford Hospital to Carryong Correctional Centre on 6 November 2019. Okay? But when we read the ABC News report, it said corrective services said the man jumped a 1.5 metre high wall and fell down the 10 metre drop on the other side. Right? He literally jumped over a fence and fell 10 metres to his death trying to escape. No justice, no peace. Black Lives Matter. Okay? Patrick Fisher. 7th of February 2018. The Guardian. Quote, Patrick Fisher fell from a 13th floor balcony in the Waterloo public housing block in Sydney in February 2018 while allegedly trying to climb down to escape from the police who had turned up at the address to arrest him over outstanding warrants. His family, who have called for an independent investigation, said he probably felt he had no option but to run or he would be bashed by police. End quote. Okay, so I downloaded the coroner's finding on this. 11. This is the quote, I'll quote you entirely now from the coroner. 11. There were 21 warnings on Mr. Fisher's police profile, including may assault police, known prohibited drug user, may carry weapon, may become violent when intoxicated, POI, has threatened to kill any Redfern police officer whilst on or off duty, warning should be taken seriously, approach with caution, consideration should be given to handcuffing while speaking to POI for police officer safety, self-admitted ice user, and perhaps most relevantly, may escape or attempt to escape, may resist arrest. And further, Magistrate C4's New South Wales Deputy Coroner said in his report, quote, I find that Patrick Fisher died on 7 February 2018 at the Sir Joseph Banks Building, 249 George Street, Waterloo, New South Wales, as a result of multiple injuries he received when he fell from a 13th floor balcony. Methamphetamine intoxication was a significant condition that contributed to, but did not cause, his death. Okay? The police came to execute a series of valid warrants upon this guy. He tried to climb down out of the building, fell 13 stories, and died. Okay? What have we got here? No, that's not it. Okay. Terry Carl, RC, or as the Guardian only named him Taz. The Guardian. Taz was critically injured when the car he was driving flipped less than a minute after police began a pursuit on Lloyds Road in Bathurst. He died in hospital a short time later, but a passenger in the car survived. The car was unregistered. The coroner's report said there was a confusion between police officers about whether the pursuit had been terminated, and the coroner reiterated a previous recommendation about defining the words termination in relation to police pursuits. She also recommended it be made clear whether a loss of vision or of a vehicle amounted to a termination of a police pursuit. So it's interesting, his car flipped less than a minute after the police began a pursuit, and there was confusion whether or not the pursuit ended. So after 1 minute, the Western Advocate. I don't think I opened that. No, I didn't. Let's just go back here. Driver jailed over police pleaded fatal crash. Okay, look at that car. It's smashed up. At the trial of one of the parties involved, it was reported Dennis had earlier failed to stop for police who initiated a pursuit before Dennis stopped the car and absconded on foot. A man who had been a passenger in the car while Dennis was driving then got behind the wheel and drove off. Minutes later, the car crashed on the Vale Road, killing the driver. Okay? There was a pursuit. It had stopped. The driver of the car tried to bolt. And then this guy moved over to the passenger seat and took off again. And police pursued him. 1 minute later, he crashed and died. According to Deputy State Coroner Ryan, in his finding, quote, toxicology analysis of Mr. RC's post-mortem blood samples detected cannabis, fentanyl, methamphetamine, midazolam and oxycodone. Expert toxicologist Dr. Judith Pearl assessed the concentration of methamphetamine to be very significant. In her opinion, it would have been expected to impair the ability of Mr. RC to control a car. Further report states, quote, the evidence does not enable the court to find that Mr. RC drove in the manner he did because he was being pursued by police, end quote. The coroner made no findings of wrongdoing by any of the officers involved in pursuit. So I wrote to the Guardian specifically on this matter earlier in the week. Dear Guardian, I'm writing to you in regard to your interactive report, Deaths Inside, Indigenous Australians Deaths in Custody 2020. In this report, the death of Taz on 27th of March, quote, Taz was critically injured. We've read that. You, the Guardian, directly quoted the coroner's report, which identifies him as Terry Carl RC, and Deputy State Coroner Ryan found that toxicology, which I've just read, impaired the ability of Mr. RC to control a car. Further, the coroner made no findings of wrongdoing by any officer. The issue is obviously very important to the Guardian given the resources the paper has devoted to the topic and the volume of coverage. I am preparing an essay on media reporting on the topic, and I was wondering if you would care to make any comment on the record regarding the following. Why did the Guardian specifically omit the severe intoxication of Mr. RC in the reporting? Why is Mr. RC's name obscured in the reporting? Further, why did the report omit the fact that Mr. RC moved from a passenger seat to the vehicle's driver's seat when the pursuit had originally come to a stop, and then continue to flee police as the driver? I expect to publish soon. Many thanks in advance, John Andrews. Of course, I got no reply to that. Absolutely none. Right. Tane Chatfield. Tane Chatfield. The Guardian. Tane Richard Chatfield died while on remand at Tamworth Correction Centre in New South Wales during a trial in which his lawyer said he was confident of being found not guilty. In the 24 hours before he was found unresponsive in his cell on the morning of the 20th of September 2017, he had been separated from his cellmate and received medical treatment for a seizure. He died in Tamworth Hospital on 22nd of September. Corrective Services New South Wales said his death was, quote, not suspicious, end quote. His family say that they received inconsistent information from authorities and do not believe he was suicidal. The inquest is pending. Okay, well, inquest had actually been handed down. And not long after that report, around the same time actually, but they haven't updated it, even though they said they would. The Guardian, that is. Reading the coroner's report and findings outlines a tragic case. There is no doubt this case is actually awful. Tane had a series of seizures and was admitted to hospital, where he stayed for observation and was returning to jail in his cell. Paperwork was late coming from the hospital to the jail, and there was a shift change, and the handover did not contain the missing information that was wanted from the hospital. And the dazed and confused Tane hung himself in his cell. The coroner found that Tane should have been placed in an observation cell until his health issues could have been properly assessed in a clinical setting. Okay, so he went to the emergency department, and he needed more specialist care than that. The coroner made a finding of intentionally self-inflicted death, but a series of recommendations regarding clinical care, particularly, quote, "I am confident that input and involvement from an Aboriginal mental health worker could have been an important component of improved care and support for Mr. Tane and his mental state. The provision of culturally appropriate treatment and suicide prevention work must be pursued." Further, the coroner ordered a transcript of the evidence of the nurse who last saw Tane alive to be forwarded to the Chief Executive Nursing and Midwifery Board of Australia for consideration of whether her professional conduct should be the subject of review. So there were no findings of any wrongdoing there. It really is a tragic case, and reviewing the literature, you see this with non-Indigenous deaths as well that occur in custody. The same issues keep coming up, where there's a slight slip in paperwork. They say, okay, well, we'll address it later. Let's just get back to the station or the prison or whatever. There's some sort of shift, or someone's sick or someone's away. It's kind of exactly the same way that the airline accidents occur, actually. And it's tragic. Okay, Dave Dungay, The Guardian. So this is the report too that was triggered earlier when we had the original report there on the July with the deaths in the Black Lives Matter protest. David Dungay, 29 December 2015, The Guardian. Quote, "In November last year, New South Wales Deputy Coroner Derek Lee found, quote, it was neither necessary nor appropriate for David to be moved and that he did not pose a security risk," end quote. He said, quote, "From a medical point of view, there was no evidence of any acute condition which would have warranted a cell transfer," end quote. However, he said that none of the 5 guards should face disciplinary action. Their conduct, Lee said, was, quote, "limited by systemic inefficiencies in training and was, quote, not motivated by malicious intent," end quote. But the Dungay family said they will fight for somebody to be made accountable for his death. Quote, "It's plain and simple, the use of force was a contributing factor to his death," end quote, Dungay's nephew Paul Silver told Guardian Australia. Quote, "If you take that use of force out, would Dave Dungay still be alive today?" End quote. Okay, so have we got the Guardian up? Yeah, that's Tane, that's dreadful. Dave Dungay, manslaughter assault charges over death in custody, a viable barrister says. Now, this is a barrister and activist for the family of Mr. Dungay Jr. And this is another awful case. So just to quote that, 26-year-old man who had diabetes and schizophrenia was... that's quoting. 26-year-old man who had diabetes and schizophrenia was in Long Bay Jail Hospital in November 2015 when guards stormed his cell after he refused to stop eating a packet of biscuits. Dungay was dragged to another cell by guards, held face down and injected with a sedative by a Justice Health nurse before losing consciousness and dying. Okay, so reading the coroner's report, and this is a huge report, I've got to tell you. On page 102, I think it's about 185 pages, I'm not certain. Cause of death. The cause of death, David's death, was cardiac arrhythmia. Manner of death. David died whilst being restrained in the prone position by Corrective Services New South Wales officers. David's long-standing, poorly controlled type 1 diabetes, hypoglycemia, prescription of antipsychotic medication with a propensity to prolong the QT interval, elevated body mass index, likely hypoxemia, caused by prone restraint, and extreme stress and agitation as a result of the use of force and restraint were all contributory factors to David's death. So footnote 338 of the coroner's report states the QT interval is the measure of electrical activities between the Q and T waves in the heart cycle and shows activity in the heart's lower chambers, the ventricles. Normally the QT intervals is about a third of each heartbeat cycle. When the QT interval is prolonged, it can upset the timing of the heartbeat and cause dangerous arrhythmias, irregular heartbeats, and abnormally prolonged QT interval is associated with an increased risk of ventricular tachycardia, a fast heart rate caused by improper electrical activity in the ventricles, especially a condition known as torsade de Ponce. Section 24.9 of the report states, Associate Professor Adams noted that David had been prescribed both chloropromazine and zoclopenthioxol, both medications of which were known to increase the QT interval. Therefore, Associate Professor Adams opined that it is, quote, it is likely that the combination of antipsychotic drugs may have contributed to the development of cardiac arrhythmia due to the combined effects or contributing to QT prolongation, end quote. The coroner found no wrongdoing and made no recommendations for charges, although did recommend changes to procedures. So, although the Guardian attempted to trivialise the justifications of the guard's intervention after he refused to stop eating a packet of biscuits, end quote, we've got to remember this was a severely mentally ill man in crisis. He had poorly managed diabetes, and a sugar spike could have had serious long-term health complications. If they'd ignored these and he had died, we would still have an issue with death in custody. Yeah, that is a tragic circumstance. A man in crisis. Reading that report is quite disturbing. But this isn't just some healthy man who was killed by prisoner guards for no reason, which is always the projection of the narrative. We'll get into that. This is going to be a long video because I'm only up to now example 6 of 14. But it's important to understand what is actually going on here. Julia Ivana Du. The Guardian, Miss Du died, quote, cutting out, end quote, unpaid fines after entering what coroner called unprofessional inhumane treatment, enduring from some police officers South Headland Police Station. She'd been told she was faking it, called a fucking junkie. She was dropped on the cell floor when she could not stand up, dragged along the floor and then carried, handcuffed and shackled to a police van because she could not walk. Her death was attributed to septicemia caused by an infection and a broken rib by her violent partner some weeks before. Her family received 1.1 million ex gratia payment and a formal apology from the Western Australian Attorney General and are still considering further legal action. We got that. There we go. There she is there, Miss Du. Now this is the WA story and it is quite awful. There's no doubt that the death of Jalikia Du is an absolute tragedy and a result of failures within WA health and police departments. The coroner's report is 165 pages long and is very thorough. The aspect of this death that pertains to Aboriginality seems to be paragraph 747. Quote, given that police officers stationed in the Port Hedland area and other regional areas would be interacting with Aboriginal persons and be responsible for their care in a custodial environment, and given what was already known about the health status of Aboriginal persons, in hindsight their training ought to have included information concerning Aboriginal persons' higher rate of common medical illnesses and susceptibility to illnesses, in paragraph 749. However, the purpose of training police officers in the health status of Aboriginal persons is to impart an understanding of the social determinants of ill health and to thereby, hopefully, avoid preconceptions being made as to the effect that apparently unusual, aberrant or atypical behaviour must be due to intoxication or drug withdrawal. Training in this area is inextricably connected with cultural competency, end quote. And crucially, paragraph 751, quote, whilst this deficiency in training did not contribute to Mrs. Du's death, more focused training in this area may have softened the attitudes towards Miss Du during the last hours of her life. Even though by this stage medical assistance was not likely to revive Miss Du, it may have caused police officers to be more readily seek it and may have made her last hours more comfortable. The failing in this instance appears to be related mainly to her examinations at the hospital. That's why the coroner says that it may have made her last hours more comfortable, because the failings at the hospital actually led to her death. So although an absolute tragedy, this is by no means the deliberate killing by the state of a young woman because she is Aboriginal. And when you look at the ABS statistics for cause of death in Australia, in 2019, chronic lower respiratory disease was the highest leading cause of death by Aboriginal and Torres Strait Islander people, ahead of diabetes. Now her last 24, 48 hours, they were terrible. She was in terrible pain. She had pneumonia. She had a broken rib. When she went to the hospital, she wasn't very specific about what her symptoms were, and there were concerns by the hospital staff that she was actually shopping for drugs. It's a really terrible tragedy, but in no way is it a murder. Okay, Rebecca Marr. Rebecca Marr it's from The Guardian again, from that website. We're the first Aboriginal person to die in New South Wales. Have I got this one up? No. Since the introduction of the mandatory custody notification service in 2000, she was taken in protective custody for allegedly walking in an intoxicated manner along a road in Cessnock. Police did not attempt to contact a responsible person as required under the relevant legislation, did not call an ambulance, and did not search her for drugs because they mistakenly believed she was HIV positive. They did not enter her cell between 1:27 a.m. When she was checked in and 5:51 a.m. when it was discovered she was dead. An inquest found that her level of intoxication and apparent breathing difficulties, which were noted by police, although some police at the inquest denied discussing the issue, meant that she should have been taken to hospital. Had an ambulance been called, the coroner found she would have survived. The coroner made 7 recommendations, including expanding the CNS, that's the Custody Notification Service, to include people taken into protective custody. And taken into protective custody means to protect herself because she was totally intoxicated. Rebecca was arrested because her CNI, her central name check, indicated that she had failed to report on bail that day. That information later proved to be incorrect. Further, Rebecca was not searched prior to being placed in her cell. If she was, 2 pill bottles may have been found, and it's contended that one of those may have been secreted in her vagina. And she would have been denied the opportunity to overdose. Police did not search her because records show, again incorrectly, that she was HIV positive, although she was accurately recorded as having hepatitis C. And police procedures gave conflicting advice on, quote, the risk of occupational transmission of hepatitis C and HIV, end quote. The report noted on paragraph 13. Rebecca also had a lengthy history of using illicit and prescription drugs from the age of 15 or 16. In November 2000, records show Rebecca reported, quote, constant, end quote, use of opiates and 5 accidental overdoses. From November 2000, Rebecca was prescribed methadone by the Hunter Newcastle Methadone Program. Rebecca continued to regularly consume methadone on prescription until the time of her death, dispensed by either pharmacotherapy service or while in jail by Justice Health. Okay, tragic case, but hardly an intent to kill. RB, 25th of October 2014. Some of these are quite quick now. Guardian, RB died of heart failure in his cell overnight, 25th of October 2014. The coroner found that the cell alarm system had not been working properly. The night RB called for assistance. Fellow inmates said they'd seen the light, but the guards had not been alerted. Due to the use of the pseudonym RB, I am unable to trace the coroner's report. I think that's a deliberate choice by the Guardian, given the manifest trend we have of reporting and what the coroner's reports actually say. And I just wonder if it isn't because the fellow inmates noted that the alert was going off, but didn't use their own alerts and didn't attempt to raise any help for their fellow inmate. Bud Lord, 19 January 2013, The Guardian, quote, Mr. Lord, known to his family as Bud, had a heart attack while in hospital awaiting gallbladder surgery. He was serving a jail sentence for driving disqualified. An inquest found his health care in hospital was adequate, but his family called for changes to the laws that allowed him to be jailed for driving while disqualified, saying they unfairly targeted Aboriginal people and those in remote and regional areas. In 2017, a 2017 review by the Australian Law Reform Commission found the laws overwhelmingly affected Aboriginal people. Bud Lord, I found, was actually named Stanley Allen Lord, and I can see why his details were hidden. When you look at the coroner's report, quote from the report, quote, "Manner of death, Mr. Lord died from natural causes while serving a custodial sentence," end quote. Full stop. That's it. I think it's a 2-page report, and most of it is, maybe it's 4 pages, and most of them are cover pages. He had a heart attack while in hospital awaiting gallbladder surgery. Now, with respect to the Australian Law Reform Commission, Bud's jailing, and the contention that the laws overwhelmingly targeted Aboriginal people, the coroner said, quote, "The road toll demands that governments respond robustly to drink driving and dangerous driving. Disqualifying offenders from driving is the most direct and obvious response, even though it will have unintended consequences in some cases." All right? So I guess that alludes to the fact that he may have been arrested for drink driving or dangerous driving, had his licence disqualified for that, chose to drive anyway, was arrested for that, went to hospital, died of natural causes. No justice, no peace. No justice, no peace. DWW, 14 April 2013, The Guardian, quote, "DWW had a background of self-harm and suicide attempts and a diagnosed history of schizophrenia. The coroner was critical of the mental health care he received. It took far too long to transfer DWW to the mental health screening unit, by which time he was in crisis. The evidence and expert opinion indicates DWW's mental health deteriorated without significantly prompt and active intervention," the coroner wrote. "He was required to undergo constant video surveillance but managed to throw wet toilet paper onto the lens of a camera about 3:14 p.m. on the 5th of April 2013. While the guards had noticed this, they did not investigate until 20 minutes later when they came to deliver him a meal. DWW was found with an apparent ligature around his neck. He never regained consciousness and died 9 days later in John Hunter Hospital. His name was David Wotherspoon." In the coroner's report, paragraph 130, quote, "There was no need or authority to resort to the provisions of the Mental Health Act, which enable compulsory treatment until David had been transferred to a declared mental health facility, an arrangement he would have voluntarily agreed to. The problematic delay from a treatment perspective was the failure to decide to transfer him to the mental health unit until the 15th of March, by which time he was in crisis. The evidence and expert opinion indicates David's mental health deteriorated without sufficiently prompt or active intervention." Going earlier then back to 34, paragraph 34, Dr. Bench decided David should be transferred to the MHSU, a mental health supervision unit, I think, at Silverwater. In the meantime, Dr. Bench recommended that David remained at the mental health unit at Cessnock under a risk intervention team protocol. Paragraph 36, however, for reasons which were not adequately explained, the form was not completed until the 21st of March 2013. Nurse Kimball indicated that she cannot now recall if the referral was to be given priority, but she was absent of work from the 16th to the 19th of March 2013 inclusive, and attended to the administrative task 2 days after she returned to work. So again, we see another tragic system failure, but it's far from a coordinated campaign to kill prisoners on the basis of their Aboriginality. Case 11 of 14, FWD, 28th of December 2013, The Guardian. Quote, "FWD had a heart attack while playing rugby at the age of 28. He never mentioned those heart problems to Justice Health while incarcerated in New South Wales, and he gave his medical history as not having a history of heart disease. He had never been diagnosed with heart disease. On 28th December, he had difficulty breathing while lying on his bed at Junee Correctional Centre and asked his cellmate to call for help. He was rushed to hospital but died, with the cause of his death listed as an ischemic heart disease. His family said prisoners should take more comprehensive medical histories, right? No justice, no peace. Man died of a heart attack, natural causes. He's on that list of people who have died while in custody. That is a complete injustice. Number 12, PB. 16 June 2020. The Guardian. PB overdosed on heroin, which had been smuggled into the Emu Plains Minimum Correction Centre by a visitor. She was only 21 years old. Guards admitted to the coroner that they would have found the contraband if they had followed correct daily procedures, including searches and perimeter checks. PB's cellmates had also failed to alert authorities to her condition during the evening. The tragedy of this matter is that, quote the report and The Guardian. The tragedy of this matter is that apart from the failings by corrective staff on the night of her death, and had any of the other inmates in House 3 chosen to buzz up, there seems little doubt PB could have been saved, the coroner wrote. Okay, her name was Paige Bartholomew, and this is actually a very, very upsetting case. I'll just point out one thing, that it said here that the overdosed on heroin that had been smuggled into the Emu Plains Minimum Security Correctional Centre by a visitor. That isn't a visitor going through the X-ray search system that you would imagine would be in a prison. They literally drove their car up to the fence. She kicked open the window, jumped out of the fence, went up to the fence. Her friend gave her the heroin and she went back inside during the night. That's how it was smuggled in. It's a minimum security facility. She just literally walked up to a chain wire fence, took drugs. Okay, it wasn't smuggled in through the system. And that's what it sounds like in that report. But anyway, this is a very, very sad case. I really do feel for this. So according to Deputy State Coroner Barry, Paige's aunt had raised Paige from the age of 13 months to 18 years. Paige's father died while he was in custody, and her mother exhibited scant interest in her. As she entered into her teens, Paige found it more difficult to reconcile the fact that her mother had no involvement with her. By the age of 18, Paige was pregnant and already addicted to drugs. Her baby was taken from her, and this exacerbated her deteriorating behaviour. Emu Plains Correctional Centre is a minimum security correctional centre for females. It's a working dairy farm utilising the services of inmates to perform dairy farm duties. Paige's friend was able to supply her with heroin from a boundary fence. The term buzz up refers to the use of an alarm that would have alerted correction staff to an issue, and several of the inmates of the house were against using the system even though Paige was showing clear symptoms of overdose. Those people were also on heroin that Paige had supplied them. They didn't want their night ruined. Absolutely terrible case, I've got to tell you. Okay, we're nearly through these. DJJ, September 3rd, 2011. The Guardian, DJJ died in his cell from medical issues relating to hypertension, heart disease, worsened by diabetes, mellitus and morbid obesity. His health problems were well known, and the coroner said there remained an intention to move DJJ to the hospital, but, quote, the mills grind slowly, especially in this country, end quote. And then it also says issues raised, medical care required but not given. Okay, so reading the coroner's report, again, this is a 2-page document. Daryl John Jones' statement. State Coroner Jerem found his treatment had been, quote, complicated by the fact that he himself had asked not to be moved, end quote, full stop, no justice, no peace. It makes no criticism, no recommendations, and found that he died of natural causes. It's absolutely ridiculous that it should be presented in that way. I mean, if they'd moved him against his will, they'd be reporting about violence against Aboriginal prisoners. Okay, the last one, 14. Mark Edward Mason. Mark Edward Mason was shot twice by a police officer during a struggle at a house at Colin Narrabri. So this is in 11 November 2010. 5 police officers went to the house to arrest Mason over an alleged allegation that he had threatened to kill his ex-partner, and over an incident where he drove at police earlier that day. He was tasered and sprayed with capsicum spray, which Coroner Hill Dillon said caused him considerable pain. Quote, he was a whirling dervish almost, trying to beat off his attackers to relieve himself of the terrible pain that he was suffering, end quote, Dillon said. He found Senior Constable Michael Babako shot Mason in self-defence because Mark Edward Mason was beating him around the head, and said Mason's Aboriginality was not a motivating factor in the shooting. So I read the coroner's report, which is very apologetic, actually goes out of its way to placate the family. What the Guardian does not mention is that Mr. Mason had rammed the police car with his own, okay, injuring 2 officers. They don't say that. They said drove at police. He rammed their car. And that Mr. Mason had threatened to stab Stacey Adams, his ex-girlfriend, and as such he had to be brought into custody. Deputy State Coroner Dillon's report contains the following phrases that describe the account. I'm not going to read the account, it's pretty brutal. Links in the description, you can read it if you want. I'm just going to read you 4 phrases. It was not unreasonable to use the taser. He did not drop the iron bar. He then began to lash out, swinging the iron bar, the tyre lever with enormous force. Any one of those blows could have killed Senior Constable Babaka. Okay, that's all that you need to know about what happened in those instances. And I just, the framing that the Guardian put on that is terrible. So what is being done? What's happening right now to turn this situation around in Aboriginal communities? We've seen that Aboriginal people are victims of crime at a higher rate. Just find. There we go. How are we going now? 1 hour. So they're victims of crime, okay, at a higher rate, and they're committing crimes at a higher rate. So what are we going to do to turn this around? What are the Aboriginal communities going to do? So at present, political activists have focused exclusively on racism, policing, prison policy and procedures as being the main contributing factors to the death of arrestees and convicted criminals. Now, I think from the 14 examples I've shown you, that's not the case. A conversation around personal and community responsibility and community, familial or indeed even tribal responses to the endemic levels of crime and victimisation within Aboriginal communities have been obvious in their absence and silenced by media, academia and activists. In a real sense, and to quote an activist slogan, silence is violence. Noel Pearson is a greatly respected Aboriginal leader, and I've had the pleasure of introducing myself to Noel at Sydney Airport over a decade ago while we were both waiting for a plane in a regional express departure lounge. Indigenous people need to take responsibility over youth incarceration. Okay? In quote, this is 3rd of August 2016, Associated Press. Quote, Indigenous leader Noel Pearson has criticised selective outrage over the Northern Territory juvenile detention abuse saga, saying Indigenous people need to take some responsibility. Pearson says more focus is needed on preventing children from entering the justice system, and Aboriginal people need to take more responsibility of the welfare of their children. Okay? Absolute legend. Stating the obvious. That's the length of that report. It's pretty tiny. It talks about that was the whole spit hood thing that was going on. Right, we've got another one here. Grandmothers unite to combat youth crime in Northern Territory town of Tennant Creek. Oliver Gordon, 22nd of March 2021. Okay, there they are. Look at those legends. Last year, the BP service station on the edge of town was a crime hotspot, the site of vandalism, theft and violence. Now, the service station hosts a nightly camp out of grandmothers and volunteers determined to stop youth offending before it happens. When we started, we were having an average of between 30 and 50 kids on the street at night, Mr. Duckworth said. Now it's somewhere between 15 and 30. We're also finding a lot more parents are actually out and about grabbing the kids and taking them home, so we're definitely seeing an impact. These are two positive media stories. These are the two positive media stories that I could find on the issue. I know that the likes of Warren Mundine and Jacinta Price are doing fantastic work in the area, and there are another two figures I greatly admire. They are great Australians. These are two small examples of how communities are taking control of themselves. This is encouraging to see, and it can only be done at the grassroots level. And we can support this by challenging narratives in order to ensure that these ideas can become acceptable and can be communicated freely. Okay, that's the challenge that we have. So let's now look at the approved discourse and the media. About 2/3 way through, okay? Let's look at the approved context, the approved formulaic media representations and the perpetuated narratives by examining what Lydia Thorpe has to say in the context of the reporting. Okay, so this is just recent, this one. Death in custody. Aboriginal man dies in Victorian prison, 11th of March, so 2 weeks ago. An Aboriginal man has died in custody in Melbourne prison. Quote, a statement from Corrections Victoria and the Aboriginal Justice Caucus was advised of the prisoner's death on the day. We continue to work closely with them in the First Peoples Assembly of Victoria. The statement said, all deaths in custody are reported to the coroner who formally determines a cause of death. End quote. Further, quote, Victorian Green Senator Lydia Thorpe said her thoughts with the grieving families and communities after 3 Aboriginal deaths in custody in Australia in a week. Quote, and to quote her, this is relentless and traumatising for our people, end quote, she said. And further, quote, the system is broken. 30 years on since the Royal Commission, how is it possible that our people are still dying in custody and not a single person or institution has been held to account? When will we have peace? At this point, you have to say the system is deeply racist. We have the solutions in the Royal Commission's recommendations, but there's no political will to do anything with them, end quote. Later, the article reads, quote, the co-chair of the First Peoples Assembly of Victoria, Jenaline Atkinson, also expressed her devastation at the death. She said in Victoria, Aboriginal people are in prison at rates 12 times higher than the rest of the population. Quote, my thoughts are with the families of those who lost loved ones, with all the community who have been impacted by deaths in custody, she said. Quote, I stand with our community in grief and solidarity and will continue to fight for safety and justice for our people, end quote. Okay, now we look at another reporting of the death of Patrick Fisher. And you will recall that Patrick Fisher is the man, the dangerous criminal who and self-admitted ice user who was on methamphetamine and attempted to scale down a 13-storey building in order to escape arrest. And this is from Green Left. Okay, so these are the allies and doing the grassroots organising or doing this activism. Still no justice for Patrick Fisher. Okay, let's read. Quote, let's quote that article. Quote, the inquest found no blame for Fisher's death could be attributed to the fact police demanded entry to the apartment, even though Magistrate Carmel Forbes said it is not in dispute that there was, however, an onus on the police to properly assess the risk of the situation before they embarked upon the arrest. Patrick's death resulted from an operational procedure that took place while he was evading arrest, raising the question as to why police did not avoid taking actions that ultimately contributed to this outcome. The inquest offered no criticism of the racism endemic within the police and justice system, which has contributed to a rise in the number of deaths in custody during the 12 months leading to August. Police, prisons and courts have proven themselves capable of only delivering murder cover-ups, obfuscation and suffering to the First Nations people. Coronial inquests are not independent investigations into the actions of police officers or prison guards. Only independent inquiries can deliver the kind of information and justice required when dealing with deaths in custody. End quote. So that's how the left-wing alternative media cover this violent offender as a victim of a system, quote, capable of only delivering murder, end quote. It doesn't look like they're doing a very good job of that. I mean, that's just disgusting. I mean, if you want to talk about cover-ups and obfuscation and suffering of First Nations peoples, you know, telling the truth would help to end that, I would simply say. To further examine the present-day framing of deaths in custody and their attendant narratives, we'll touch on an article by Latoya Arua Rule. Firstly, I need to point out that her brother died in a police van in 2016 while being transported. The coronial inquest into his death is yet to conclude and present a report. The Victorian response to COVID-19 may be affecting the operation of the inquiry. I don't know. And if I had the report, we would go over it. Rule has my deepest sympathy as the loss of her brother. It's an enormous tragedy for a family to lose a loved one, especially in the prime of their lives. Rule, you have my deepest sympathy. No Australian deserves to die in an untimely manner. Okay? And she writes, who is accountable for our deaths? January 13, 2019, The Guardian. So she wrote this, quote, I worry that Aboriginal deaths in custody have continued as common practice and in fact normalised in prisons and police systems. I reflect on the symbolism of the coroner's court and how recommendations are largely made to change practices within the prison and strengthen the prison's ability to accommodate more Aboriginal peoples rather than abolish the systemic racism that supports the prison industrial complex in the first instance. I think about the discourse this creates deriving from the lack of justice for our people's deaths. End quote. It's very tortured language. Further, Rule goes on. In 2015, I posted a video on the ABC's Q&A television program calling on the Australian government to respond to the pressing issue of Aboriginal deaths in custody over symbolic reform. My video to the Q&A panel posed the question, at the time of the 1991 Royal Commission into deaths in custody, Aboriginal people accounted for 1 in 7 deaths. That number has now soared to 1 in 4. If the government's response to Indigenous issues is to remove symbolic representations of racism from the Australian Constitution, will there ever be practical change? Or is it time that us First Nations peoples sought international aid? End quote. So there's much to comment on just these 2 paragraphs, but I'm going to focus on the last sentence. Okay, the last sentence. Is it time that us First Nations people sought international aid? There are 2 phrases. Oh, sorry. Hang on a minute, I'm going to get back to that one. I'm talking about the first paragraph. The discourse this creates deriving from the lack of justice of our people's death. I've put that in the wrong spot. Anyway, let's just look at what she said about international aid. Okay. We note here that Rule is a hardcore identitarian even before the tragic death of her brother. He died in 2016, and this quote that she makes herself is available from 2015. So she quotes herself asking that question in 2015 before her brother died. Okay. Now, if we look at that issue of international aid, this actually comes from a strain of thought within Aboriginal activism that they are First Nations, and as independent nations, they are independent from Australia and can seek their own foreign policy. And that's sort of outlined in this document at a youth assembly. This is from 2012. And there's a media release that says here that appeal to internationalism. Is it time that us First Nations people sought international aid? It's a kind of disembodiment from the reality in this question. To become independent within Australia, that they need foreign help to become more cosmopolitan. And as an inherent contradiction, in order to get self-determination, we need international third-party assistance. That's not self-determination. The next to note is that there's an implicit assumption in the premise of a question from her perspective that she does not consider herself part of the Australian nation. She identifies as First Nations, as being separate from the nation. And that there are many of them, and that hints to they're entitled to pursue an independent foreign policy outside of the nation. And that's part of that tradition. And this is also good old-fashioned sedition, I have to say, and although we've diluted our sedition laws to nothing, if we still had the War Precautions Act of 1914, that would have been a Commonwealth offence for any person who by word of mouth, in writing or in any act or deed, advocates, incites or discourages disloyalty or hostility to the British Empire or to the cause of the British Empire in the present war, or advocates the dismemberment of the British Empire, or who says or does anything calculated to incite, encourage or assist disloyalty or hostility shall be guilty of offence under the Act. Now, I'm actually all for those sort of laws, sedition laws in this country, and we got rid of them with the national security legislation in 2010, and it really waters down an offence only to be an offence if and the phrasing in the legislation is urging violence. All right. So incidentally, in this demand I see a very toxic sort of female energy. The framing is emotional, and the death rates of prisoners are devoid of context of the rates of crimes, the rates of victimhood, and a call to action that's based on that attempted manipulation, and then a threat to lash out or humiliate if that manipulation isn't successful. I think you see a lot of that toxic femininity in most of the postmodern projects, and this is a very, very clear example of that. Another aspect of that toxic femininity is the arrogant self-righteousness that emboldens someone to make those manipulations and demands, even with the false framing and the threats of retaliation. It's absolutely absurd. So we go back to the article and another article of hers. Here she lists some victims. Now this is the one that I had, I wanted to bring it to. So The Guardian, my hope for March for Justice and beyond is what we consider the plight of black women in Australia. Is that we consider. Now, according to The Guardian, Latoya Arua Rule is an Aboriginal and Maori Takatabui person residing on stolen Gadigal land, presumably one half of herself to stole it from the other. And they are a PH candidate at UTS, an education and friendly science. They're all pronouns, the whole thing's there, it's all there on display. In 2017, Latoya completed her social work honours degree, and her thesis focused around the death in custody of Aboriginal woman Ms. Du, and the ways in which Ms. Du and Aboriginal deaths in custody victims have largely been held responsible for their own deaths through discourse of Aboriginality as inherently criminalised. Have largely been held responsible for their own deaths through discourse of Aboriginality as inherently criminalised. So it's important to note that what you've heard is not a sentence. They're two phrases butted together. It's grammatically retarded. Now, if you'd written something like discourse of criminalised Aboriginality, that would be a sentence. Okay, but this is part of the language. So what does she mean by discourse? If we look at the social justice usage of discourse from the website newdiscourses.com, which is a fantastic resource, the link's there if you're interested in how the postmodern left and social justice advocates are working. That is a great resource. Discourse means at its simplest written or spoken communication, however, is more specifically means ways of talking about things, or more accurately, ways that things can be talked about. That is, discourses are, in some sense, the linguistic systems that are created by our boundaries on acceptable and unacceptable uses of language, okay? If we rewrite Rule's phrase, we get Aboriginal deaths in custody victims have largely been held responsible for their own deaths through discourse that criminalises Aboriginality. Okay, so the linguistic trick here is to write something that seems intelligent but is actually simultaneously impenetrable and unintelligible, yet also infers meaning rather than state something absolute that can be verified as being false. Indeed, if you read any of the coronial reports linked below, you will not see a single example of discourse that criminalises Aboriginality. However, discourse of Aboriginality as inherently criminalised carries no meaning outside of whatever the reader takes to it. It is a phrase designed to capture prejudice and the prejudices and the projections of the reader. Also, the phrase is designed to decouple the concept of custody with crime by delegitimising the concept of Aboriginal people being subject to the criminal justice system. Further, we've gone through the case of Ms. Du, and there is nothing in the coroner's report that contains discourse that holds her responsible for her own death, okay? In the article, Rule explains, quote, I question why black people are fighting for gender equality between cis men and cis women when equality has not yet been achieved between black and white women in the first instance, let alone women who are transgender and or binary and gender non-conforming people, end quote, end quote. Calling for justice for black women requires a call to end the systems that oppress black women, a call to end the overrepresentation of Aboriginal women in custody, a call to end deaths in custody, a call to abolish the carceral state, and even more so, a call for decolonisation, end quote. Note the focus here, the protection of solidarity with those who self-identify and other carefully chosen identitarian groups so as to disconnect them from the whole of the nation and the body politic, to wedge division rather than bind together in mutual respect and commonality. Identification of cis and trans categories is deliberately done to ensure that people of a Christian or conservative disposition are excluded from cooperation in the struggle. So what does she mean by decolonise? And we go to the Social Justice New Discourses website for the social justice usage. Just to be clear, Victoria Rule is saying that by using the term abolish the carceral state, she wants to abolish prisons, okay? And jail is not a legitimate form of punishment for any crime of any degree of severity. Further, according to newdiscourses.com, decolonisation is best understood as a deconstructive and reconstructive project within social justice to remove white and Western influences or centrality from essentially any and everything. Okay, that was a quote. What this demonstrates is a change in the framing of death from misfortune, whether by deliberate state intent or unintended consequence, to unjustifiable brutality by the state in every instance and context that seeks to, quote, oppress black women, end quote, specifically. This is what she means by discourse. It's basically talking about how you talk about things, and it's got nothing to do with reality, and that's why the statements are always indefinite. But they sound definite and they sound smart. Okay, so we'll move on now. Oh, there she is there. And there, presumably in her room, with an Aboriginal flag and a burning police car, okay? Right? No justice, no peace. The guy that dies waiting for his gallbladder surgery or has a heart attack. Driving away from lawful arrest, climbing down a balcony and falling. It's everyone else's fault. Nick Gooder says Northern Territory government backing away from Youth Detention Royal Commission findings. Let's have a look at that. To quote the relevant part, the government also wants to expand a list of offences that do not allow young people to face court with a presumption in favour of bail, including for break and enter into premises, unlawful use of a motor vehicle, and assaults against police or workers. Mr Gooder's criticisms echoed complaints from local and international NGOs on Tuesday, including Amnesty International and the Human Rights Law Centre, that labelled the changes politically motivated. But some groups have welcomed the government's proposal, with support for tougher measures coming from the NT Chamber of Commerce and the Northern Territory Police Association. Mr Gooder clearly remembers the day he handed the Commission's final report to the NT government. End quote. The point here to make is simple, that Royal Commissions can make recommendations from a set of narrow terms of reference, but political decisions on legislation are made by the Parliament, and the Parliament derives its authority from the ballot box, not from experts, NGOs, activists, or the media. In too many areas of public life and political debate, the points of view of so-called experts are put forward totally unchallenged, or are only ever challenged insofar as those points of view challenge pre-existing orthodoxies. Right, let's look at the perpetuation of these narratives now. Division in trust over Indigenous deaths in custody continues as recent events open up old wounds. So 6 days ago, so this is the 20th, Aboriginal lives matter. Nobody said they didn't, right? Isabella Higgins, and this is flagged by the ABC as being analysis. Now this is important. Can you see here? This says analysis. This is not reporting. This means opinion. 3 years ago, when that young man was 17, he watched his 2 friends drown in front of him while they were all trying to escape from the police. A group of youths ran into Perth's Swan River trying to outrun 2 police officers pursuing them after a nearby break and enter. End quote. The quote goes on. The man, who for legal reasons was referred to only as P, watched footage showing the police officers entering a powerful, wide stretch of the Swan River in a rescue attempt. His response to the video of tactical response officers in the water was blunt. Quote, He could have gone sooner, end quote. She goes on, quote, if you can't trust that young man's anger and distrust, let me try and explain. This is where the opinion comes in. It's not just him, but his immediate circle and the broader Indigenous community who are angry that their people are still dying this way, running away from police and jumping into a swift flowing river and then complaining that they're not saved fast enough when they drown, right? This is narrative perpetuation. Pass my phone, pay my mind, okay, that's it. I present this as a perfect representation of narrative perpetuation. By disguising an opinion piece as analysis, the author is able to present a work that has the appearance of straight, unbiased reporting when it is in fact deliberate and selective perpetuation of self-justified victimhood, and it's done so in an entirely uncritical way. Aside from perpetuating the approved discourse, this narrative-driven account has the effect of actively discouraging self-reflection and growth within the Aboriginal community, giving justification to grievance rather than opportunity to grow. Okay. Now I've got another article. Here's why Black Lives Matter resonates in Australia. Okay, now this is reflective of what's going on, of a big problem. Now this is by Ray Steinwell. And it says, quote, Black Lives Matter is also speaks to a more profound connection between Indigenous Australians, African Americans, Asians and other minorities. One has to be black or coloured to actually feel it. It's about bonds that unite all coloured people, something innate, not taught, simple, powerful, uniting, the knowledge that the oppression of one is the oppression of all, end quote. Ray Steinwell is Associate Professor, Faculty of Law, a white university scholar, senior counsel in large corporations, and has been a solicitor for the High Court and member of the Australian Competition Tribunal. How could he, by his own logic, make that truth claim? That doesn't matter. The media will print it because this is racialised thinking at its very worst, and the propagation of an idea by a white man that all black people all around the world somehow share some collective bond that is innate, powerful and uniting. Can you think of where you've heard those arguments before? So I've heard those in the 1930s in Europe. Anyway, we've got another one now about BLM. I actually love this article. BLM advocates push for police floats to be removed from Sydney Mardi Gras. Okay. The article says in part, now a motion has been put forward to the group calling for a ban on the New South Wales Police Force float and the New South Wales Corrective Services float in 2021 and into the future. The motion states, quote, it is in recognition of the ongoing violence perpetuated by police and corrective services towards First Nations communities, end quote. And while the motion calls to ban the police-associated floats, members of the force would still be able to participate in the Sydney Gay and Lesbian Mardi Gras out of uniform, end quote. Now this may surprise some of you, but I actually agree with this. I agree with Black Lives Matter on this issue. It's good to agree with Black Lives Matter on an issue. Police and New South Wales Corrective Services should be excluded from the parade, but not because the so-called deaths in custody, but because the Mardi Gras is sick, disgusting and degenerate behaviour that is corrupting our youth, and that isn't the issue for this topic, but it's worth mentioning. And I think if BLM think that this is some kind of own, some sort of disrespect to New South Wales Police and Corrective Service, I have to say to you, you're proving that you have no solutions to these issues, and your focus on the police and not the perpetrators and the victims, who, as you've seen, are disproportionately Aboriginal. It's absurd. Just get out of the way. You are hurting, not helping, and you are dividing. Your diversity and your division is hurting Australia and unity between Aboriginal and non-Aboriginal people. So now that we're talking about Black Lives Matter, let's talk about Black Lives Matter. Okay, so last year they came to our shores, the innocuously and inaccurately named Black Lives Matter. Okay, and this is about her story. Look at these. Right. Let's read about Black Lives Matter from their own website. As organisers who work with everyday people, BLM members see and understand significant gaps in movement, spaces and leadership. So this is all a quote, right? Black liberation movements in this country have created room, space and leadership mostly for black heterosexual cisgender men, leaving women, queer and transgender people and others either out of the movement or in the background to move the work forward with little or no recognition. As a network, we have always recognise the need to centre the leadership of women and queer and trans people. I copied and pasted those. Again, the grammar is absolutely appalling. So their focus is on women and queer and trans people. So all those men dying in custody, and we're pretty pleased about that. Okay, so we'll get to that though. BLM protest, unacceptable risk, ban court order. So this is obviously during COVID sort of times. And this focuses the thing that we started, the first article we looked at with the death of David Dungay. So Paul Silver, quote this article, Paul Silver, whose uncle David Dungay Jr., 2015 death in custody was a rallying point for the protest, said, quote, "We need to see action and we will not be silenced," end quote. Quote, "This decision to push ahead has been made by the family and we thank our supporters who are standing with us," he posted on Facebook. Quote, "Whatever happens in court, we will be leading a rally in Sydney on July 28. End quote. End quote. Mr. Silver said he wanted New South Wales Premier Gladys Berejiklian to order investigation on whether charges can be laid over the death of Mr. Dungay, who he claims was killed by prison officers in Long Bay Hospital. So you recall that was the guy who was having a mental health crisis. He was on medication that affected his heart, and during the struggle he had a heart attack. Terrible case, but hardly murder. I would like the Premier to confirm that Black Lives Matter in New South Wales by asking for that investigation. If she refuses, then it just goes to show that no one cares about our lives, and we'll see you on Tuesday. Okay, so we covered the case of David Dungay, his tragic death, the mental health crisis, and the case studies, and the coroner found no wrongdoing. We saw the reporting on his death at the start of this essay, with media reports citing systemic issues and clear failings that yielded no results when searched for in the findings or in the report and in the recommendations. But the media and BLM are not interested in truth or facts, and the media have no interest in challenging narratives that give them cheap and easy content. BLM know this and they exploit it. From all the metrics we have seen, Aboriginal Australia is in crisis. And what is BLM response? To further degenerate social bonds within the community. And how do they do that? Let's look exactly how they do that, about how they are actually corrupting the Aboriginal community. BLM site removes page on nuclear family structure amid NFL vets criticism. So this, you might have heard of this. On a now deleted about section on their website, BLM made the following statements about the goals of their organisation. Quote, "We are self-reflexive." I'm going to bring this up because I've got that. "We are self-reflexive and do the work required to dismantle cisgender privilege and uplift black trans folk, especially black trans women who continue to be disproportionately impacted by trans antagonistic violence. We have built a space that affirms black women and is free from sexism, misogyny and environments in which men are centred. I like men. We practice empathy. We engage comrades with the intent to learn about and connect with their contexts. We make our spaces family-friendly and enable parents to fully participate with their children. We dismantle the patriarchal practice that requires mothers to work, quote, double shifts, end quote, so that they can mother in private even as they participate in public justice work. We disrupt the Western prescribed nuclear family structure requirement by supporting each other as extended families and villages that collectively care for one another, especially our children, to the degree that mothers, parents and children are comfortable." In this sense, right, so end quote, right? So in that sense, in disrupting the family, there's actually no difference between BLM and the Aborigines Protection Board of New South Wales that we started this essay with. BLM stands in direct contrast to Aboriginal tradition. And let me just demonstrate exactly how that's done. This is the Uluru Bark petition. Now, this was a petition that was submitted to Parliament by Aboriginal people against gay marriage, against homosexual marriage, queer normativity. And just to quote the website here, the heart of the petition states that marriage between man and woman is and always has been sacred to the oldest living culture on earth. The petition adds that fathers and mothers who are deeply honoured in Aboriginal culture also form, quote, the foundation of our families, clans and systems, and pass down our teachings, our cultures, our traditions from one generation to another. So that's the website quoting from the petition itself. Aboriginal communities are extended kinship networks that have been disrupted. The nuclear family has been interrupted by the actions as described in Richard Broom's Aboriginal Australians, A History Since 1788, that I opened this essay with, and by Honourable J.H. Walton QC's report in the inquiry of death of Malcolm Smith, who killed himself by driving a paintbrush in his eyeball in Long Bay Jail in 1983. So we've seen the consequences of disrupting the family, and it's formed the basis for all the activism that BLM has been a part of in order to do exactly the same thing. Okay, the quote that I read in part earlier said that in order to attempt to solve the Aboriginal problem by the Aborigines Board, that they attempted to solve that problem by the deliberate destruction of families and communities, which was the policy of the Aborigines Protection Board. And here we have Black Lives Matter inserting themselves into this country, looking to do exactly the same thing. Their stated goal is to disrupt the Western nuclear family. That's what they want to do. Okay, these are not solutions. This is absolute division. So I've just got my conclusion now. I'll wrap it up. It's only going to be a couple of minutes. This essay started with a question: was the phenomenon of Aboriginal deaths in custody murder, myth, or mayhem? Of the 432 protested deaths mentioned in the media reports cited, there is only one example where an officer has been charged with murder, which was in WA. And I didn't cover that in the case study because it's open. It's still pending. Of all the examples reached, there have been no recommendations of charges for either murder or manslaughter. There is no valid reading of either individual instances or the deaths collectively to determine that Aboriginal people are being murdered or systematically killed by the criminal justice system. There is no prima facie evidence for this, and if there was, that would be the focus of intense scrutiny of the system, of a system that routinely goes out of its way to accommodate the sensibilities and vulnerabilities of Aboriginal people. This is not an issue of murder. Aborigines are dying in police custody, police and corrective services custody, as are every other single demographic. Human populations have mortality rates. We cannot live forever. The danger in peddling the myth of Aboriginal deaths in custody, BLM propaganda, is because it undermines trust. At some point in the future, there may be a crisis requiring urgent attention be directed toward the Aboriginal population, but crying wolf is not going to get the trust required to deliver in such a circumstance. From the data, we've seen that. I'm going to go through some numbers here. 2 in 5 prison entrants have been told they had a mental health condition, 1 in 4 taking medication. Of those, with almost 1 in 4 in total, sorry. 1 in 5 prison entrants reported a history of self-harm. 3 in 4 deaths in prison were of natural causes, 1 in 4 were suicide or self-inflicted. 18% of all deaths causes were, deaths from all causes were Aboriginal from a population that is 28% Aboriginal. Death rates are 1/3 lower than the rest of the prison population. We've seen that Aboriginal people are vastly overrepresented as victims of crime at the hands of their own demographic. Some key figures in the Northern Territory and Torres Strait Islander. 69.7% assault victims, 30% of the population, majority were female. More than a quarter were aged between 25 and 34 in New South Wales. 8.4% of sexual assault victims, 3.4% of the population. In Queensland, 11.6% of victims, 4.6% of the population. South Australia, 6.1% of sexual assault victims, 2.5% of populations. And for those sexual assault victims, the majority were female across the states, between 78 and 95%. And across all of the jurisdictions, 1/3 of them were aged between 10 and 14 years of age. Okay, where is the female-centred Black Lives Matter? That 1/3 of sexual assault victims, of Aboriginal sexual assault victims in New South Wales, Queensland and Northern Territory are aged between 10 and 14 years old. 10 and 14 years old. In South Australia, about a quarter were aged between 15 and 19. So, I mean, they're still children. Most knew the offender, and across all jurisdictions that was 62 to 84%. In relation to intimate partner violence in New South Wales, 12% of women killed identified as Aboriginal versus 1.7% of the population, and 31% of men killed identified as Aboriginal against 1.6% of the population. So we can clearly see from the evidence that Aboriginal people are overrepresented in the prison system because of massive crime rates being perpetuated by Aborigines against other Aborigines, and to deny this reality is simply an attempt to create mayhem. Stop hurting your own communities and yourself. Stop blaming a system that is overstretched trying to keep you alive, and do better. Why is it that Aboriginal people that are decent, that obey the law, that are civic minded, why are we supposed to feel sorry for a demographic that disproportionately commits crimes, and that the victims of those crimes are disproportionately also members of the same demographic, and yet no one talks about it? Why are we supposed to feel guilty because they die in prison, as we have demonstrated, at rates below the rest of the prison population? If Aboriginal activists and BLM were to say, look, Aboriginal people are vulnerable, we have elevated risks of disease and mental illness, and when in custody we need help. There have been instances where one of our demographic have killed themselves or died in circumstances where systems are broken down, when we would say yes, okay, we want to end that too, but we in turn also are concerned about the crime rates going on in those same communities. Young girls and women are vulnerable to assault and sexual assault, domestic violence in the streets, mostly in the Northern Territory in the streets, but also in the home. And we ask you to own that so we can all move forward. Continuing the quote from the report into the inquiry of the death of Malcolm Stewart, the Royal Commission into Aboriginal Deaths in Custody that started this essay, and I've already revisited, said, quote, the attempt to solve Aboriginal problem by the deliberate destruction of families and communities, which was the policy of the Aborigines Protection Board and was to some extent its successor, the Aborigines Welfare Board, has not only wrecked individual lives, but is seen by many Aboriginal people as falling squarely into the modern definition of genocide. Now that same quote, that exact same paragraph then goes on to say, few would openly advocate such policies today, but unless continuing positive steps are taken to understand and counteract them, there is a risk that long-standing racial attitudes will continue to influence the formation and implementation of even more enlightened policies. In particular, it is essential to stop treating Aboriginals as dependent people whose welfare is looked after by others who know better than they, and give them back the opportunities for self-reliance, independence and self-respect that was so cruelly taken away and denied them for most of the last 200 years. End quote. This is essentially what lies at the heart of the future, how we move forward together as a nation. Right now, Aboriginal people are victimising each other. Their lands are locked up under common law title. Okay, community title. They can't do anything with it. And 40-year-old narratives centred on deaths in custody that don't stand up to the most elementary scrutiny that you've seen here today are destroying self-respect, crushing independence and opportunities to participate fully in the Australian life that every Australian citizen deserves. I was struck by a paragraph from the Mason inquest after Mark Mason was shot by a police officer. You'll recall he attacked that officer with an iron bar, which read, quote, the thing is that in Australia we are Siamese twins. We're joined at the hip. The white people can't go and the Aboriginal people aren't going. We can live in resentment and anger and hatred and corrode ourselves, or we can try to overcome the bitterness that separates people. I can't say to anybody here, the police officers or the Mason family or others, what to do, but I suggest that all of us, if we simply live in that intensely corrosive mindset, are hurting ourselves more than we hurt those whom we hate, end quote. So I just ask you, is the narrative that we are perpetuating, is that helping or is that causing mayhem? All right, thanks for watching. That was pretty intense. And yeah, cheers. Comment, share.